Welcome everybody, here in Maastricht and as well online. I hereby open this academic ceremony in which Ciro Leal, Martins da Cunha will defend the academic thesis, Alcohol Control, Regime Interaction between WTO Law and Global Health Law. May I invite you to present a summary of your study and the conclusions of your thesis.
Dear Madam Pro-Rector, highly esteemed members of the Corona, esteemed colleagues, dear friends and family, online viewers. Alcohol occupies a unique position in international regulation. It's a major traded commodity with deep cultural, social, and economic significance. At the same time, its consumption entails risks that are universally recognized. That is why states have traditionally had intense regulation and market intervention in that particular commodity. This includes measures such as taxation, price controls, and advertising restrictions, and in more severe cases, even prohibition. Internationally, alcohol control has been a subject of regulation since at least the late 19th century. The modern era in the World Health Organization has been on the agenda since the very first World Health Assembly in 1948. However, such discussions have not resulted in a binding international convention or binding norms. In public health circles, the situation leads to a common refrain that alcohol remains the only psychoactive substance that causes dependence that is not regulated by an international binding norm. The idea that such a gap in international law should be remedied has become even stronger with the adoption of the Framework Convention on Tobacco Control in 2003 by the WHO. For many global health experts and advocates, the success story of the FCTC has become a roadmap that should be replicated in the realm of alcohol control, leading to the negotiation and eventual adoption of a Framework Convention on Alcohol Control, the FCAC, as they call it. A central claim in favor of that convention is that a binding instrument would be needed in order to provide a line of defense against international trade law, especially the law of the World Trade Organization. And according to that view, free trade commitments, especially at the WTO, are almost inherently at odds with the appropriate alcohol regulation. This brings us to the research questions of my dissertation. First, we inquire to what extent WTO law actually constrains alcohol control policies that are supported by WHO instruments. Second, we try to answer whether a WHO convention on alcohol could mitigate these challenges and still remain consistent with international trade commitments. And third and final, whether there are alternatives short of a binding convention that could serve the same purposes. The stakes of the matter are far from trivial. On the upside, the alcohol industry generates millions of jobs and billions of dollars in tax revenue. The global alcohol market exceeds $2 trillion a year, and international trade in alcoholic beverages surpasses $100 billion a year. On the downside, the harmful use of alcohol is a causal factor of more than 200 disease and injury conditions. It is also attributable to alcohol over 2.6 million deaths a year, a death burden that surpasses that of HIV/AIDS, tuberculosis, and malaria combined. The fiscal and health burden of alcohol use is believed to reduce GDP up to 1.6% a year, according to the OECD. Against this backdrop, one of the main challenges of the research is that alcohol is a topic marked by intense and competing interests: industry, health advocates, governments, consumers, and so on. And that tends to generate relative polarization and little objectivity. In order for us to address the questions as objectively as possible, I methodologically adopted the concept of regime interaction. WTO law and global health law were seen as separate legal regimes whose rules and institutions nevertheless affect each other in practice. I proceeded in the dissertation to briefly describe both regimes. On the one hand, WTO law is a highly legalized regime with binding instruments and a strong dispute settlement system, albeit, as we know, in a bit of a crisis. I highlight the agreements and provisions that constitute the main avenues for regime interaction in the WTO law, such as the general exceptions at GATT, Article 20, and the TBT agreement. On the other hand, global health law is highly fragmented and relies on soft law instruments mostly, despite the fact that the WHO is at the center of the global health law and has treaty-making capacities. The main instrument on alcohol control is a soft law instrument, the WHO Global Strategy to Reduce Harmful Use of Alcohol. It was adopted in 2010, and it sets out a range of policy options for states to adopt. They're encouraged to adopt as they see fit. In 2022, a global alcohol action plan, 2022-2030, was adopted by the WHO in order to fully implement the global strategy. One of the main innovations of that document is that it brings voluntary goals for member states to pursue, including the reduction in 20% of harmful use of alcohol. Beyond the WHO, the UN system at large also adopted soft law commitments present in the 2030 Agenda for Sustainable Development and in 3 United Nations General Assembly resolution, political declarations on non-communicable diseases, where alcohol control plays a central role. In the analysis, regime interaction is defined broadly and goes well beyond situations of conflicts of norms. I divide these interactions into 3 basic categories: administrative, adjudicative, and legislative. Within each category, I analyzed the most significant expressions of regime interaction, utilizing a predominantly inductive and empirical perspective. I will now summarize the main findings in each of these categories. With regard to administrative interactions, I analyzed over 100 alcohol trade-related concerns raised in the Committee on Technical Barriers to Trade and in other WTO bodies. The main finding is that there is a significant interaction, particularly in the TBT Committee, where concerns relating to labeling are especially prevalent. This may indicate a lack of clarity regarding regulatory policy space. It might also point to tensions between prohibitive norms from the WTO law on the one hand and permissive norms emerging from global health law. However, the analysis also suggests that the existence of a binding convention on alcohol would perhaps not bring substantial difference in outcomes. That's because by analyzing the tobacco-related trade concerns, I found that the level of tension and lack of clarity was not too different. An alcohol convention would, however, offer member states defending their alcohol policies a higher profile and stronger basis for them to defend their alcohol policies at the TBT Committee and other fora at the WTO. Still, on administrative interactions, I also analyzed the instances of cooperation and coordination between WTO and WHO. The goal was to assess whether the existing norms allow them to offer greater policy coherence both at the international level and at the domestic level for member states. I found that the existing legal instruments already provide ample space for such cooperation. Among the examples that are listed in the study are a joint study by both secretariats, the participation of both WTO and WHO in multi-agency efforts such as the Standards and Trade Development Facility, and the UN Interagency Task Force on NCDs. While not indispensable for that effect, an alcohol convention could offer additional opportunities for inter-regime coordination. It could function as a political platform for prioritization and mobilization of resources, since one of the main challenges that was mentioned in many of those interagency initiatives was indeed lack of political priority and lack of resources. As for the adjudicative interactions, I examined 14 alcohol-related disputes in the WTO dispute settlement system, as well as 4 disputes at the GATT from the GATT area. The main finding here was that alcohol-related disputes do not reveal conflicts of norms or incompatibilities between the regimes. In all cases analyzed, the disputes originated from protectionist measures rather than health-oriented policies. There was no indication of significant constraints on policy space for alcohol control. On the contrary, in several cases, the adjudicators, be it panelists or appellate body, went out of their way to explicitly emphasize the rights of members to utilize health-oriented alcohol control measures, such as minimum prices, and even import monopolies. It is also very telling that Article 20b of the GATT was invoked by the defendant in only one instance in a GATT-era dispute. And in that case, the defense was not even analyzed by the panel because the measure at issue was found to be GATT compliant. As for, in order to assess the potential impact of a convention on alcohol-related cases, I also analyzed 3 tobacco-related disputes at the WTO, where the FCTC was raised by either party, be it the complainant or the defendant. The main finding here is that a convention on alcohol would not be applied as a source of law or operate as a legal defense, as it has not been the case at the tobacco-related disputes. A convention on alcohol would therefore not be a silver bullet that some advocates on the health side would expect with regard to trade-related commitments. It is clear at the same time that a convention like that would still carry significant evidentiary weight in disputes as a reflection of scientific consensus in support of alcohol policies. And that is no small feat. As the Australia tobacco plain packaging case demonstrates, the FCTC played an important role in the interpretation and application of crucial provisions of the TBT and the TRIPS agreement. With regard to legislative interaction, I adopt a prospective approach, also drawing again on the experience of the FCTC. I found that in case of actually drafting an alcohol convention, if that arrives to be the case, the active engagement of the WTO and its secretariat would be crucial to promote policy and legal coherence between the two regimes. Potential normative tensions could be reduced or even eliminated by conflict-sensitive treaty design, for example, through conflict clauses and harmonious interpretation clauses. A comparison with the history of the FCTC, however, indicates that an alcohol convention does not seem politically very viable at the moment. It lacks 2 crucial elements that led to the tobacco instrument back in 2003. First, a strong and willing leadership within the WTO, and second, a mobilized public opinion and civil society against the industry. In that context, I argue that a binding instrument is not the only legislative pathway forward. I analyzed 3 main alternatives. First, the adoption of additional soft law instruments, for instance, a code of conduct on alcohol advertising. Second, the adoption of subsequent agreement and authoritative interpretations by the WTO through its agreements and its governing bodies. And third, the establishment of relevant international standards. And in this latter case, the ongoing work of the Codex Alimentarius Commission on alcohol labeling standards presents the most promising avenue, as it addresses the topic that has been the most contentious in this regime interaction. Taken together, these findings support a broader conclusion. The interaction between WTO law and health law in the field of alcohol control is best understood not as a story of conflict, but one of cohabitation or managed coexistence. While a binding convention on alcohol control could play an important role, progress can be also achieved by other means. My dissertation offers an intentionally limited contribution to ongoing discussions on trade and health governance. My hope is that it may help foster a better informed and more constructive dialogue among all players in the field. In this respect, I note that the year 2030 will be an important moment for global alcohol policy. That is when the WHO global strategy will be reviewed, that's already mandated. And it could be a naturally reopening of the possible discussions on the merits of a mandate to negotiate an alcohol convention. The analytical tools developed in this thesis are intended to contribute to such a discussion should it arise. Thank you so much for your attention. I look forward to the questions, and I give the floor back to the director. Thank you.
Thank you very much for your presentation. The opposition will be opened by Professor Dominic Coppens. Dominic Coppens is a professor of international economic law at the Faculty of Law of this university, and he has acted as the chair of the assessment committee. The floor is yours.
Thank you. Yeah, I would like to congratulate the candidate for the rigorous work that you've done, both in the book but also today in the presentation. I think the strength of your thesis lies in its comprehensiveness, and I found it particularly interesting to see how you trace back historically also alcohol regulation and how you then discuss it both from the angle of international trade and health law. And I think you convincingly demonstrate, I think as you discussed today as well, that both regimes have developed in parallel, almost in separate silos, and that there is potential for conflict, although that conflict should not be exaggerated, so it seems. And so I think your thesis has definitely succeeded in breaking down the academic silos between the two regimes. And I hope and I believe that it may also help to break down those silos in reality with policymakers. So I would like to congratulate you with the work that you've done. My question would also like to zoom in to an aspect that you touched on briefly in your thesis, and that's the regime interaction and how alcohol instruments could be used in WTO disputes. So if you would put yourself in the shoes of a complainant, of a defendant before the WTO, how would you rely on the WHO instruments that are currently in place, like the global strategy? And would that be any different if we had an alcohol convention like the FCTC in place? Would your strategy as a defendant be any different? Thank you.
Thank you very much, highly esteemed opponent, and thank you first for your kind remarks. Really appreciate them. With regard to the question, that's a very crucial question to this discussion. My understanding of this possible defendant's strategy in that situation is that, of course, the existing instruments in global health law regarding alcohol control could definitely be used as arguments in favor of some interpretation of terms or the application of certain provisions in the WTO agreements. I just like the fact that the FCTC, even being a binding convention, was not applied as a source of law. As a defendant, I would not dare present the current WHO instruments as a source of law. I would, however, present them as a source of interpretation. For instance, if that would be the case in the necessity test of Article 2.2 of the TBT agreement, or even a necessity test of Article 20 of the GATT, or even regarding the unjustifiable encumbrance test in Article 20 of the TRIPS agreement. The fact that we have already had disputes where the FCTC was raised and in a way or another attempted to be presented as a source of law, and it has not passed that bar, would make me a bit hesitant to present even a framework convention on alcohol control as a source of law, expecting that to bear fruit in a defense before the WTO panel or appellate body.
Thank you. If I may just follow up on the question. So I think what you also explained in the presentation is that you use it more as a source of evidence. At least that's how the FCTC has been used as a sort of evidence. Now, if you now switch position and if we're thinking about you as being a complainant, do you see any concern with a panel relying on an FCTC or in your context on an alcohol instrument as a source of evidence, not as a rule of treaty interpret, not help to interpret treaties, but for instance to say, well, this makes a meaningful contribution towards reducing consumption, relying on an alcohol instrument to essentially bolster that point. As a complainant from the perspective of, do you see any concern with that? Do you see any concern also with the WHO intervening as an amicus in those proceedings to precisely try to support such a position?
I think as a complainant, it has been done with regard to the FCTC in the past, that the complainant themselves would raise the FCTC even when they were not parties to that agreement, as attempt to show that the measure at issue would be was being too restrictive, even by the FCTC standards. So I think that's a point that should be taken into consideration when we talk about an FCAC as a possible counterweight to WTO agreements, is that it can also be used as a double-edged sword by either party. I think at this point it should be expected, if you're a complainant, that the defendant would be raising those arguments based on international instruments from the global health law. And yes, I think it would be only natural that the complainant would be prepared to deal with that and to try to frame their claim based on the fact that the previous cases on tobacco utilized the FCTC as evidence and not as a source of law. And I think the complainant should strategically try to steer the discussion towards showing that the measure at issue is too restrictive, even by the alcohol control standards.
Thank you.
The opposition will be continued by Professor Gabrielle Marceau. Welcome, Professor Gabrielle Marceau, at our university online. She is a professor emeritus of international economic law at the Faculty of Law at the Université de Genève, and she has been a member of the assessment committee. The floor is yours.
Thank you very much for including me, and congratulations to the candidate. When I read just the table of content the first time in my first read, I was impressed by the logic and the analytical framework followed by the candidate, which to me announced a very, and it was said already, comprehensive and good analysis. In particular, also, congratulations, because you're an outsider, for what was just discussed, recognizing that such eventual convention, even if it would just be a fact and not applicable law, would nonetheless be extremely important, not only for the impact in society, but for its role in the overall sort of adjudication process. The fact that such treaty is a fact, what you call evidentiary weight, doesn't mean it has no value. And a final congratulations for your awareness of the importance of soft law, and I would even add possible sort of plurilateral agreements and other sort of areas where this policy issue can be pushed, even legally, because soft law is also rule of law. My only little comment is that I would not see them as alternative, but they can be implemented together with, and many things at the same time for something so important. My question is about your reference to this case law. To my knowledge, there's nothing much of a discussion useful by the appellate body in the case law when alcohol called or would have called for a health sort of exception. Or, and I'm linking together, I know it was done for cigarettes, but alcohol and cigarettes are a little bit different. And I'm just jumping quickly because I may come up with a follow-up. When you go to church on Sunday, if you're Christian, the priest drinks alcohol. So what was not discussed in your thesis are the type of provisions. Because as you know, the case law is clear that there's a difference between an import ban, a label, maybe a regulation, higher taxes. these different policy tools, these different measures will call for different assessment, but are there, in your view, really today, so far, case law interpretation on the invocation of health consideration for alcohol restrictions or discrimination? Thank you.
Thank you very much, esteemed, highly esteemed opponent. Yes, first of all, thank you so much for your very kind and generous comments. They are really appreciated by me. Regarding the question, I admit that perhaps the research was not as comprehensive as it could have been in terms of analyzing potential questions raised vis-a-vis health and trade. I understand that some of the existing case law would have been interesting to be analyzed, but were left out of the scope of the study for some practical reasons, I would say. I think it comes to mind the case Brazil retreaded tires, for instance, where the where Article 20B was raised and of the GATT was raised, and there was intense discussion whether it would pass the necessity test, and which it did, but then didn't pass the chapeau test. I think that would be a possible, say, case that could appear in future alcohol-related cases. But I concede that there was no additional exploration of case law other than the alcohol-related cases and the tobacco-related cases in my dissertation.
Thank you, but I'm not blaming you because I think there's no full discussion of the health exception applied to alcohol measures. There are lots of alcohol measures, but so maybe for a follow-up question, if there's a second round, I will raise the issue of any differences in policy justification between, for instance, tobacco and alcohol. But for now, I'll stop and I'll just congratulate you again. And I encourage you to sort of publish this if it's not as a book, because as I said, the line and the analytical framework is extremely good, even if some aspects could have been, in my view, deepened a bit more. Thank you.
Thank you very much. The opposition will now be continued by Professor Geraldo Vidigal. Professor Vidigal is an associate professor of international economic law at the University of Amsterdam. Welcome to our university. You've also served as a member to the assessment committee, so the floor is yours.
Thank you, Ms. Chair. Like the previous opponents, I found thesis very comprehensive, and it provides a very strong and well-informed and well-researched overview of how these two regimes interact. I learned a lot, especially, of course, about the tobacco regime, the alcohol regime, which is not heavily discussed in trade law, contrary to, for example, tobacco. And I also quite like the fact that you included the trade concerns, which is something that lawyers sometimes skip over because they seem less legal. There's less material for us to work with. But of course, in terms of how states and WTO members actually address their disputes, they are very important, and they're being given significantly more light by the Secretary these days, which is a good thing. In terms of what I would have liked to see more, and again, I think I follow up with from Gabriel, the idea that you look at this regimes from a sort of bird's eye perspective, and of course you capture a lot. But when you get to the actual interaction, which is maybe justifiable in a place like this, and in a piece like this, and it being, of course, a PhD thesis, you're also excused for trying to be on the safe side of your committee. But I would then like to press you a bit on, how this would actually work. Because, of course, the issue with the tobacco control case is that it applies to all tobacco, domestic or imported, whereas what happens in the cases involving alcohol normally involve some sort of product differentiation between alcoholic products rather than a total prohibition or a full taxation, although some of these GATT cases that you mentioned correctly accept that this would be, if it's non-discriminatory, is acceptable. And the question then goes to, how do you then deal under Article 20 with these differences in treatment of different products? And the first one, I'm going to ask you to address two points so that I don't have a follow-up question. One is, how do you see the sort of Chile alcoholic beverage situation where a country member differentiates between products on the basis of alcohol content, which just so happens to coincide with the products that are produced domestically and externally. And of course, there's also case law in the EU about this. And secondly, now, how would you see the interaction between this and immaterial cultural heritage? Because in 2024, for the first time, the UNESCO inscribed in its list of immaterial cultural heritage Japanese sake production. Now, and of course, many other countries may see this with interest, right? So of Peru and Brazil, and why not? That's why everybody wants to have their own national alcohol. And would that then justify a different treatment between domestic and imported products to preserve national cultural production methods? Thank you.
Thank you very much, highly esteemed opponent. First of all, let me thank you for your very kind and generous comments, which I take to heart. Regarding the differentiation between domestic and imported products, two of the three cases on tobacco control that were analyzed, they actually identified a discrimination with regard to imported tobacco products. In the U.S. club cigarettes case, the fact that mentholated cigarettes were excluded from the prohibition because mainly of cultural and political circumstances in the United States led to the conclusion by the panel and then the appellate body that the United States was in breach of Article 2.1 of the TBT agreement. And similar situation, although by a different provision and a different agreement, was found in the other case involving the Dominican Republic. Basically, there was some sort of discrimination against imported tobacco products. So I think that, and the tobacco plain packaging case was the one that didn't show, at least in the conclusions of the panel and the appellate body, any sort of discrimination against imported or imported products. And that's what one of the reasons why it led to the conclusion that Australia was complying with the agreements. Regarding the second question about the situation of the case of Chile alcoholic beverages, it is a very, I think it used to be until that case, I guess, a relatively common strategy by domestic authorities to, in a way or another, I might be too hard on them right now, but in a way to disguise as health-oriented differential taxation what is in fact and in practice by the structure and nature of the measure a discrimination against imported products, like the highly esteemed opponent mentioned, that some degrees of alcoholic content were surprisingly or not surprisingly associated with higher taxes. But still, in that case, the appellate, I'm not sure if it was the panel or the appellate body, made it very clear that differential taxation based on alcohol content is a valid and acceptable policy as long as it, of course, does not discriminate against imported products. And finally, with regard to the issue of cultural heritage, that's definitely an aspect that I should look into with greater detail. It's something that I didn't explore in the dissertation, but it's very interesting, as of course it could bring some future questioning in terms of the consistency with WTO agreements. I would guess in a very quick manner that one of the forms whereby the such cultural heritage products would be favored nationally would be by the concession of subsidies in a way or another. And still we haven't seen any dispute regarding subsidies conceded to alcoholic beverages and the WTO dispute system. But I would assume that that would be the more likely route whereby states would give some sort of preference to their, say, culturally related alcoholic beverages.
Are you satisfied with the answer?
Thank you, yes.
The opposition will be continued by Professor Hildegard Schneider. Professor Schneider is Emeritus Professor of European Law at the Faculty of Law of Maastricht University, and you have served as a member of the Assessment Committee as well.
Thank you very much, dear, and thank you very much for being invited to this committee. Dear candidate, I was very impressed when, as the other members of the committee already said, when I looked first in your book, especially also on the very clear structure of the book and the content. I was also, when I received the book, very impressed by this beautiful picture, which I think showed very well the content also of your dissertation. When I was reading your thesis, I must admit I'm not such an expert in the panel reports of alcohol, but I got back to my teaching of substantive EU law and all the important arguments of member states when they try to defend their preferences, why fruit-based alcohol was a much better issue than grain-based alcohol in France, for example, which means cognac is allowed or can be taxed lower than whiskey. So all this, and I also remember the German government saying that additives are the worst in beer. When Germans would drink, I don't know anymore how many liters of beer per year, where the British judge, I think, thought that when they really drink so many liters beer, there might be other problems than just the additives. So this all brought me back to when I read your dissertation. But when I come to the end of your dissertation and the conclusion, and I think you're absolutely right argument that at the moment there is no political climate, let's call it like that, for an alcohol convention, I was also thinking, but how would you really draft such a convention? Because I think it was already mentioned, I think that I'm not a smoker, so it's easier for me to say tobacco is rather one product. I mean, even if you have menthol and other tobacco, but it's tobacco and it's dangerous. Alcohol beverages are from 3% to 90%, I think. So there is an enormous variety, and I would say some are perhaps less dangerous, some have cultural heritage status, some others have are dangerous because they are combined perhaps with soft drinks, which makes them looking soft but are hardcore alcohol and very dangerous. So, and meanwhile, I would say in Europe at least, drinking non-alcoholic beer is becoming more favorable than alcoholic beer. So we have a very great variety. So I was just puzzled, how would you ever draft such a convention? And how could you balance, because with tobacco, when I was reading again the convention, I thought, yeah, that's rather clear, but how would you draft such a convention? So even if it's political, not feasible, perhaps I invite you to think, how would you deal with all these differences?
Thank you so very much, highly esteemed opponent, and thank you so much for your very kind and generous comments, and which I really appreciate. With regard to the question specifically on how to draft such a convention and regarding a very a product that's quite varied in its presentations and its origins and its ingredients as well. That would be a challenge. What comes to mind is the fact, for instance, that the Convention on Tobacco, it was initially, I mean, it is, legally speaking, confined to products that contain actual tobacco, which does not necessarily cover some products, some smoking products that are being sold in the market these days. I mean, the following conferences of the parties and guidelines have touched upon that, limitation, and they have tried to deal with it. But the fact is that new products that weren't covered initially are currently being the object of cooperation under the umbrella of the FCTC agreement and the FCTC Secretariat. So I think in terms of drafting, there should be, in my opinion, in the case of an alcohol convention, there should be a very broad definition of what constitutes an alcoholic beverage. In many countries, such definition is basically a minimum alcohol content definition. In my country, I think it's 0.5%. That is considered to be an alcoholic beverage. Anything below that is not an alcoholic beverage, legally speaking. And the non-alcoholic beer that the highly esteemed opponent mentioned, technically it has a little alcohol in it. It's just like kombucha has a little alcohol in it. So it's a matter of in my opinion, setting the bar low enough to cover most of the products. At the same time, one thing that the highly esteemed opponent mentioned that is very important is the actual presentation of the product. And I think that has an interesting correlation with smoking products. For instance, the FCTC has been very clear in its guidelines and discussions that any additives that mask the bad flavor of tobacco should be forbidden or at least limited. And of course, whoever's selling the tobacco wants it to taste as easy as possible for the consumer, especially if it's a young consumer, because then you get consumers for 20, 30 years. And I think that should be a concern as well for a possible alcohol convention, to be very specific in covering this type of strategy that aims at acquiring new clients, especially if they're underage. To have answered your question.
Thank you.
The opposition will be continued by Professor Jennifer Sellin. Professor Sellin is an assistant professor of international law at the Faculty of Law of Maastricht University. Welcome to this opposition. The floor is yours.
Thank you very much. Also, thank you for the very kind invitation. Also, congratulations on the thesis. I really enjoyed reading it, although that is not my expertise, but I learned also a lot. So I thought that was very interesting. So I would like to ask a question about the seeming discrepancy between your title, the dissertation's title, and which is regime interaction, and then between WTO law and global health law, and your central research questions, where you limit, or where your approach is limited to the WTO law and the WHO, World Health Organization. So you seem to then equate global health law with World Health Organization law. Even in your first chapter, you recognize that global health law is a very fragmented field, but that there are a number of cross-cutting principles, and one of those is the right to health, and this is central to the global health. To global health law. But then in your subsequent analysis, there seems to be very little attention paid to global health law. So even if your focus would be limited on World Health Organization, so the approach of the World Health Organization, the question then still remains, considering that the World Health Organization has committed itself to a human rights-based approach to health, why is that not more prominent in your subsequent analysis? Thank you.
Thank you very much, highly esteemed opponent, and thank you so much for your comments and your question. It is indeed a point well taken that the bulk of the discussion regarding regime interaction deals with takes as an input the WHO instruments and law, and does not delve as much into other instruments. I do go through in the dissertation the activities and norms of the UN system, both the Sustainable Development Goal framework and the UN-based non-communicable disease agenda. I think there's a more, say, mundane reason for not having touched upon the say so very substantively on the issue of human rights agreements, which is the fact that they were not raised in the interactions that were analyzed. I do acknowledge in the first chapter that they are an integral part of the global health law regime, which is a very central aspect for me personally, because the formulations, even though the World Health Organization, as the highly esteemed opponent mentioned, has adopted a rights-based approach, it is still, I would say that rights language is not the preferred language in WHO circles. They're, by training, most of them are doctors or non-lawyers in general. And I think one of there's always been an idea of coming up with a resolution or even a treaty or some sort of instrument regarding the right to health within the WHO, and that has been favored by many countries, but of course has been resisted by so many other countries. So it has never borne fruit. I think that's the main reason for the discrepancy. Going back to the first reaction, is that and unfortunately, I would say that the references to other sources of global health law have not necessarily appeared in the interactions that were analyzed. And there's also the fact that the WHO is at the center of its the specialized agency for health of the UN system, and it's at the center of the discussions on health. But I would say that yes, I would have expected there to have been more references to human rights law and even reports of special rapporteur on the right to health and so on in the interactions. Thank you.
Thank you.
Very good. The opposition will be continued by Professor Iveca Aleksovikova. Professor Aleksovikova is Assistant Professor of International Economic Law at the Faculty of Law of this university. And the floor is yours to ask also a question.
Thank you very much. And thank you also for the invitation to be part of this interesting defense. Congratulations with your work. Just like others, I found it very interesting especially, of course, parts that I am less familiar with. So the book really provides an interesting overview of both trade law and also health law and their interaction. You examine administrative, adjudicative, and legislative interaction between these two regimes, and you find, and as stated also in your first proposition, that there is no evidence of conflict of norms or other forms of incompatibility between international trade norms and policies supported by global health law. And I would like to focus on this point, actually. You provide a useful overview of WTO disputes that were somehow related to alcoholic beverages. And you find that none of these disputes really involved issues of health. The Article 20B was only once invoked, as you explained as well in your presentation, but not really further addressed because there was no need for that. This overview, for me, it also confirms that genuinely health-related alcohol control measures are not being challenged unless they have some kind of protectionist features, which are then being challenged rather than the health objectives behind them. Well, there are then no health objectives, obviously, in these cases. Well, what I would like to ask you, you really focused on the regime interaction and state that there is no evidence of conflicts of norms or other forms of incompatibility between international trade law and policies that are supported by global health law. Yet, at the outset, you do recognize that that there is a tension between international trade, maybe international trade law, that favors trade liberalization, which leads to greater market access for products, including alcoholic beverages, obviously. And this then directly or indirectly actually or potentially leads to greater consumption of alcohol because there is more availability at a lower price, more variety, which is then interesting for consumers. And I see a tension, you even mentioned there was this tension between trade liberalization and then global health law objectives, which would mean the less alcohol consumption, the better, which is in tension with the more alcohol beverages on the market, the better. Yet you do not really address this tension in your work any further. Rather, you focus on disputes, on the administrative cooperation, on possible cooperation in the legislative part. Should a treaty on alcohol control be adopted and how that would work, which is very interesting. But I still have a problem with this main tension between trade law, standing for liberalization of trade, including in alcoholic beverages, and global health law that would preferably see as least alcoholic beverages on the markets as possible. Could you please maybe elaborate on this?
Thank you. Thank you so much, highly esteemed opponent, and thanks so much for your comments and your question, which I think it's a point that's that is I mean, the tension between free trade in general, not free trade norms, but the idea of free trade on the one hand, and health on the other is something that's very that's commonly addressed in the, I would say, mostly in the global health literature, and I think it has very much to do with the adoption, especially in developing countries, post-colonial countries, of consumption patterns that resemble those of developed countries or Western countries. And that, of course, includes alcoholic beverages. And you see some references to the relatively aggressive way in which multinational companies try to enter these newly and developing markets in ways that are sometimes disruptive. I think there's a very interesting, there's some interesting cases of policy and political opposition to that sort of movement in Southeast Asia, mostly which is one of the regions where alcohol consumption has actually been increasing, unlike, say, Western Europe or even the Americas, where it's been slowly decreasing. At the same time, I understand that that kind of tension would belong more to the economic realm and not to the legal realm, because it is, at least in my opinion, it is very clear that there's nowhere in WTO law that says stops a country from imposing exorbitant taxes on every alcohol that's sold. There's even countries where alcohol consumption is, for the most part, prohibited. I think the WHO database shows that some 10 or 12 countries in the world have an ongoing prohibition on alcohol, and they have, of course, not been subject to any dispute. Of course, those countries are mostly of the Islamic tradition, which, as we know, forbids alcohol. And so far they have been successful, let's say, in keeping with their prohibition. So I think in some, I think there is a tension between free trade, which means, in a way, cheaper goods, more access to foreign goods, in general, more access to foreign and Western associated products like alcoholic beverages. At the same time, legally speaking, there is no, I mean, there's a relatively large space for countries to adopt measures that are as extreme as prohibition without, say, any trouble. So there is definitely a tension between the ethos of free trade, let's say, and health, which does not necessarily mean a legal tension. That would be my opinion. Thank you.
The opposition will be continued by Professor Dominic Coppens.
Yeah, I think with such an excellent thesis, you may well be asked tomorrow by your government, or if not by other governments, where to draw the line and whether a particular alcohol-related measure could indeed be adopted, and where to draw the line between what is acceptable or not under WTO law. So if the government would come to you and ask you whether they can implement tomorrow plain packaging for alcoholic beverages, which is an idea that has been floated around, would you say, based on your analysis, also in light of some of the case law that you mentioned, like Brazil tires and the EU palm oil case, would you say, go ahead, this is fine, the risk is low, if not non-existent, that this will be successfully challenged, or what would be your opinion for the government? Thank you.
Thank you. Thank you very much, a highly esteemed opponent. I think that touches on a very, very interesting speculation, and as you said, an idea that has been floated of plain packaging for alcoholic beverages, and I think that's perhaps one of the nightmare scenarios for alcohol producers, because from a, say, economic and marketing perspective, you know, alcoholic beverages, they're not necessarily too hard to produce, not necessarily too expensive to produce, you know, so there's great value in the brand, and the brand includes, of course, the...
You may briefly follow up the answer, please.
Much. So yeah, there would be definitely great concern by producers, and I suppose there would be some sort of dispute caused by a possible plain packaging measure. I think, say, the goodwill that, or the lack of goodwill that exists with regard to tobacco, based on the science and on the culture and on the history of tobacco, perhaps that same lack of goodwill would not apply in a panel or appellate body with regard to alcoholic beverages. So I would advise my government to be very careful and to have its science very clear before adopting such a measure, because that would be definitely contested, and perhaps because alcoholic beverages doesn't hold the same negative denormalization that tobacco has gone through, it would be less safe than it has been in, say, Australia or Uruguay to adopt that kind of measure. Thank you.
Thank you. Ciro Leal Martins da Cunha, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return in this room.
excited?
Yeah, yeah.
Please be seated. Ciro Leal Martins da Cunha. The degree committee here present has assessed the quality of your thesis and your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Prevost is authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite first Professor Prevost to confer upon you this degree, and afterwards Professor van den Bossche to speak the laudatio. Please all rise.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible? By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Ciro Leal Martins da Cunha, the degree of doctor, and grant you all rights attached by custom and law. As an evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Dear Dr. Leal, it's my great pleasure to be the first to address you with your new doctor's title. Congratulations. The road has been long and challenging, but as they say, that makes arriving at destination more gratifying. I remember well when you first contacted me almost 10 years ago. You contacted me to ask whether I would be willing to supervise doctoral research on alcohol control and WTO law. Now, I was intrigued because, yes, I mean, at the appellate body secretariat and later as a judge, I had done some work on alcoholic beverages as a senior legal advisor of the appellate body members. I had been on Japan alcoholic beverages too, on Korea alcoholic beverages, and on Chile alcoholic beverages. And as a judge, I had been in Philippines distilled spirits. But to be fair, and some of the members of the committee have also made that comment also here today, these were not cases on alcohol control. Actually, they were cases on the opposite. They were cases on the promotion and protection of domestic over imported alcoholic beverages through, most of the time, through differential taxation. So alcohol control was new to me, but the exploration of the regime interaction between, on the one hand, international trade law and global health law seemed very interesting and worthwhile to me. And I was very happy that Denise Prévost shared my assessment of this and was willing to join the team as co-supervisor. During many years, our work as supervisor was relatively light because you were probably my most independent PhD researcher I've ever had. And that's a compliment. You were very self-motivating. And while we did have, or you had, occasionally online contact with us, and in particular with Denise, I think I only met you twice in person, both times in Geneva. And it's one of the two times that I remember very, very well. I've got fond memories of them because we were having lunch. It was summer. We were having lunch on the restaurant of the WHO on the terrace overlooking the Lake of Geneva. Wonderful memory. And at that time, you really convinced me, this may take time, but this is going to be good research. And now here we are again in Maastricht at the end of that long process. And as I understand it, this is your very first time that you are in the city of Maastricht. During the years that we have known each other, and I think it's important to emphasize this, you have made an impressive career in Brazilian diplomatic service. Since 2021, you hold the rank of minister and are the alternate permanent representative of Brazil to the Organization of American States and the Pan American Health Organization, both based in Washington, D.C. I knew that, but what I did not know, and when I read your CV, it took me by surprise, but a very pleasant surprise. Over the last years, you have also obtained an LLM. And an LLM in national and global health law at Georgetown Law. Well, there are a few places better to get into this field than there. All this makes finishing the PhD thesis even more impressive. Denise and I are truly proud to have been your PhD supervisors. And we congratulate you, but also your family, because we know in academic circles that certainly for PhD students that do this on the side, it's the families that suffer. So congratulations to the family, and we wish you all the best in your future academic, hopefully academic, but definitely professional career. Thank you very much.
Dear Dr. Leal Martins da Cunha, it's also my very pleasure to congratulate you also on behalf of Maastricht University with this degree. It's the highest degree that we have on offer, so it's really something to be very proud of, and I would also like to extend the congratulations to your partner and kids and everybody online that contributed to this success. Before I close this academic ceremony, I would like to ask you and the Paranyms to stay here for a minute. We will take a picture in front with also the online member, and afterwards we will also take a picture outside at the stairs. The company present here can await this picture to be taken, and afterwards we all will move to the Refter for the reception. Thank you very much, and I hereby close this academic ceremony.